Hello everybody, welcome to iExamBee's Legal Bee. This is Amrita, your law faculty here at iExamBee. In this video today I'm going to discuss with you all relevant content for AAI Junior Executive Law Examination. I have seen many queries of the students relating to some subjects from this exam syllabus like Public International Law, AAI Act and so on. Students को ये difficulty है कि इन subjects को कैसे पढ़ा जाए एंड बाकी के सब्जेक्ट्स में से भी क्या क्या इंपॉर्टेंट एरियाज हैं. आई वुड सजेस्ट एवरीबडी टू चेक आउट द प्लेलिस्ट ऑफ लीगल बी. इन दैट वी हैव कंटिन्यूड अ सीरीज or rather completed a series of how to study all these topics from exam point of view. So I would suggest all of you to immediately subscribe to our YouTube channel and check out the playlist. इस वीडियो में मैं आपके साथ क्या डिस्कस करने वाली हूँ? That is MCQs. Now you will be thinking that MCQs, what kind of content will be discussed. पब्लिक इंटरनेशनल लॉ ऐसा सब्जेक्ट है जो कम्प्लीटली थियोरटिकल है एंड काफ़ी स्टूडेंट्स को डाउट है कि क्या पढ़ना है क्या नहीं पढ़ना है. उसके लिए तो आप हाउ टू स्टडी वाली सीरीज देख सकते हैं, लेकिन क्वेश्चंस किस तरीके के आएंगे, दिस इज़ अ वेरी बिग क्वेश्चन इन द माइंड्स ऑफ स्टूडेंट्स, स्पेशली फ्रॉम दीज टॉपिक्स. पब्लिक इंटरनेशनल लॉ जैसे अगर मैंने आपको कहा ये पूरी तरीके से थियोरेटिकल सब्जेक्ट है, तो इसमें से किस प्रकार के क्वेश्चंस हम एक्सपेक्ट कर सकते हैं. According to that, you have to be ready and you have to do your revision also in that manner. So we are going to discuss some sample questions in this video. You can also download the PPT for your reference. I would suggest all of you to download iExamBee's app for free mock test access, and don't forget to subscribe to our YouTube channel. If you have any queries, you can reach out to us through any of these mediums or directly comment in the comment section of this video. Who is said to be the father of modern international law? Now this basic first question I have taken up. International law, modern international law, who is said to be the father? थियोरेटिकल सब्जेक्ट्स जैसे जूरिस्प्रूडेंस है वैसे ही इंटरनेशनल लॉ भी हम समझ सकते हैं. यहाँ से इस तरीके के कुछ क्वेश्चंस हम एक्सपेक्ट कर सकते हैं. जेंटिलस, ग्रोशियस, लॉटरपैक्स, थॉमस रूदरफोर्ड. Now these are names if you have not read about them, but at least you must have heard that Grotius has did a lot of contribution in public international law. So he is the father of modern international law, Hugo Grotius. He has contributed a lot and he was a strong believer in the true sense of international law. So I would suggest all of you to have a strong base of the theories. ऐसा नहीं कि आपको एक नाम पे ही क्वेश्चन आएगा, वी कैन नॉट प्रेडिक्ट, बट अगर आप ये एरियाज पे फोकस करते हैं या कुछ बेसिक लोगों की डेफिनेशन ध्यान में रखते हैं लाइक J.C. Stark, Grotius, then definitely it will help you understand their ideologies, and then those who don't accept international law in the true sense like Austin. So इससे क्या होगा, आपका बेस स्ट्रांग हो जाएगा एंड अगर इस एरिया से कोई क्वेश्चन आता है, आपको बेसिक पता है तो आप आंसर कर सकते हैं. Hugo Grotius was a Dutch philosopher and he's widely recognized. He has actually made he has written a book on that, on the law of war and peace in 1625, long time ago. So he has actually done the groundwork for the international law principles, and that's why his contribution is very important and we consider him to be the father of modern international law. Which one of the following scholars considered international law as true law? जैसे मैंने आपको कहा ये क्वेश्चन काफ़ी इंपॉर्टेंट है. अब ये सारे स्कॉलर्स के नाम हैं, इनमें से कौन कंसिडर करता है इंटरनेशनल लॉ को एज अ ट्रू लॉ? नाउ द आंसर हैज बिकम वेरी इजी फॉर यू. इट इज़ ऑफ कोर्स Grotius, which we just have studied. Grotius is known as the father of international law, but obvious he must have given a strong base of international law and he has definitely considered international law to be a law in the true sense. बाकी के जो भी ऑप्शंस है, हॉब्स, हॉलैंड, ऑस्टिन, इन लोगों ने इंटरनेशनल लॉ को रिकग्नाइज नहीं किया है. एंड ऑस्टिन स्पेशली एवरीबॉडी नोज ही गिव्स अ लॉट ऑफ इम्पोर्टेंस टू द sovereign authorities, which he feels that it is lacking in international law. Next question. How many primary sources of international law have been listed in Article 38 Clause 1 of the Statute of International Court of Justice? Now this kind of questions also you can expect. Completely theory से आपको ये भी प्रिपेयर्ड रहना ज़रूरी है कि आपको इस तरीके की क्वेश्चंस, स्पेशली सोर्सेज ऑफ इंटरनेशनल लॉ बहुत ही इंपॉर्टेंट टॉपिक है. सो आर्टिकल 38 तो आपको thoroughly प्रिपेयर करना ही है. आर्टिकल 38 ऑफ द स्टैट्यूट ऑफ ICJ. How many primary sources are there? How many sources are there? That is one thing. And how many primary sources are there? That also you should know. So the answer is D. 3 primary sources of international law are there. And as per the order in which they are mentioned, the order of importance is also there. Number A will be the most important source of international law. And then you will see that clause D is talking about the subsidiary sources. So this categorization you should be aware of. A is international conventions, treaties. B, customs. C, general principles of law recognized by civilized nations. So these three are the primary sources of international law. Thoroughly be prepared with this article, clause D and subclause D of clause 1, and clause 2 also is very important. The concept of ex equo et bono, these things are very basic, so you have to do it properly. Do revise it. Doctrine of pacta sunt servanda is a principle governing. This is also a very commonly discussed principle from international law. So the meaning of that, its application, its correlation with other sources of international law, everything you have to be aware about. Who has given this? Recognition of states, treaties and international law, sovereignty of states, recognition of governments. So this principle is talking about which of the following concepts? Recognition, treaties, sovereignty of states या recognition of governments. Recognition of states, recognition of governments. अब यहाँ पे minute difference आ गया. तो अगर आपका concept clear है तो आपको ज़रा सा भी time नहीं लगेगा. Options में आप confuse नहीं होगे. Treaties in international law, because the meaning of the concept is that only agreements must be kept. It is a Latin phrase and that is giving a strong foundation and binding force to a treaty. What is missing in international law is binding force only. So that is being provided by way of this particular maxim, that we have to be bound by our agreements. This principle is also an important area. Recognition of a new status, a political act, legal act, quasi-legal act, constitutional act. Now what kind of concept is recognition? Recognition, types of recognition, all these, de jure, de facto, everything is very, very important. Now it is a political act. Remember that. Recognition is a political act. Recognition is a political decision which the sovereign states or governments are making out. International law also develops through state practices. Now if state practices are there, it is developing into an international law. This will come under which source of international law? This you have to interpret over here. Whether it is a treaty, whether it is an international committee, whether it is internationally customary law, whether it is international morality. कौन से कैटेगरी में जाएंगे? ऐसे क्वेश्चंस के लिए क्या करना चाहिए? ऑप्शंस देखने से पहले भी आंसर मन में सोच लेना चाहिए कई बार. तो फिर क्या होता है, कंफ्यूजन नहीं होता है, क्योंकि आपके माइंड में एक प्राइमस फेसी आंसर आ जाता है, एंड देन व्हेन यू सी द ऑप्शंस then you get clarity in that. So international law develops through state practices. This is what is the development of customs. This is very important. We all know what are customs, what are usages. Practices only turn into usages and then ultimately turns into customs. This is also a very important source of international law. And opinio juris, this concept is what is talking about it. Legislative functions of United Nations are usually within the domain of. Now UN को भी आप skip नहीं कर सकते. Definitely you have to be aware about the basics organs of the UN and what functions they are playing. So legislative functions, who is going to play? Very easy it is. General Assembly. All these options, I hope you all are very clear with the basic structure and what are the functions of all these authorities. Nottebohm case is relating to. Now in public international law there are various cases, so I could not stop myself of including one question relating to case laws. I cannot be very sure about cases here, but I would suggest you people, as per availability of time and as per your preparation. If you have already gone through the cases, then definitely there is no harm in revising them at this point of time. If not done, then you may leave it. But if you have done it, you should definitely revise it. Now, Nottebohm case is relating to the concept of nationality. Nationality, this is also an important area from public international law, and this has been discussed in the Nottebohm case. Nationality is a legal bond, and it is having its basis as social fact of attachment, genuine connection, and also it reflects the identity of a person, which is conferred by a state. Preemptory norm of international law is just cogence, general principles, treaty, international committee. Now all these concepts, what happens if your concepts are not clear, it all gets jumbled up. So that's why your concept should be very clear. It's a theoretical subject but also very conceptual at the same time, let me tell you. If your concepts are clear, you can definitely score in this subject also if questions are asked from this area. Preemptory norm is just cogence. Just cogence is a preemptory norm and it is a principle of general principle of international law. What it says, just cogence norm includes prohibition on the use of force or prohibition against torture, law of genocide, etc. ये सारे जो principles हैं, ये सारे general principles हैं international law के, and nobody can violate them. This is something which we have to be very sure about. Nobody can violate these principles. Nobody can go against these norms. Last question for today. Which of the following conventions is not relating to airspace? Because the exam for which you people are preparing, that is the aerial law, relating to that, whatever is there in international law, hijacking, and all these areas you need to have a hold on. Now there are conventions that are relating to airspace, defining what is airspace. Not one, but there are many. So I would suggest you people to be aware of them, be acquainted with them. Basics, not very detailed, but at least the basics. So which of the following conventions is not relating to airspace? They have asked you over here. Be very careful of this word not. Many times we skip this and then we suffer. So which is not relating to airspace? Montreal, Vienna, Hague, Tokyo. So Vienna Convention is the law of treaties is relating to it. Montreal, Hague and Tokyo all are relating to airspace. So this was all that I had to discuss with you all. All the best to everybody for your exam preparation. Do well, and if you have any queries, do reach out to us at iExamBee. Have a good day. Thank you everybody.